Good morning, good afternoon, and good evening, wherever you are in the world, and welcome to the second broadcast of the I-Team, the international podcast discussing data law issues. I'm here with my usual cast of suspects and partners, Jonathan Armstrong, partner at Punter Southall Law from the United Kingdom. Also from the United Kingdom, Fiona Campbell, who is head of e-disclosure and also a commercial litigator at Fieldfisher. And coming to us from South Africa, Linda Sheehan, executive at E&S. We have a guest with us, a special guest. We're going to have a little bit more of America on this broadcast with Kelly Twigger. She is CEO of a Minerva 26, and she is also the principal of ESI Attorneys, a law firm specializing in electronically stored information, if you don't know what that abbreviation is. Kelly Twigger, welcome, and thank you for joining us on the I-Team.
Thank you so much, David. What a pleasure to be here with this illustrious group.
Well, we at least try to be illustrious, whether we're talking diamonds or shiny new automobiles, perhaps the van used by our inspiration, the A-Team. And of course, we have our standard disclaimer here. No one is giving legal advice. If you have a legal issue, please seek competent counsel. And of course, no one is speaking for their employers or other associations here on the I-Team. And with that, let's get into the discussion. We don't necessarily have a theme for today. One we thought was lawyers behaving badly, but we also want to let you know that sometimes things can happen in the least unexpected ways. You may call an expert witness in a case, and you don't think much of calling an expert witness, but that could lead to big consequences down the road. Perhaps you have a client who has a marvelous disinfecting machine. That could get you into trouble. You don't know how, but it might happen later on. And, hallucinations in artificial intelligence. It's been a big topic around the world. The French researcher, Damien Charlatan, I hope I've got his name pronounced correctly, has now had over 230 cases in his database of hallucination cases that have gone wrong. For those of you who aren't aware of hallucinations, it is when artificial intelligence has a seemingly correct answer, but may not be. And we're going to have some theme on that. And generally that is, it's not the tool, it's user error oftentimes. Let's start with our special guest, Kelly Twigger. There's a case recently, and it involved an expert witness, and it was a medical research case. How did they get into trouble on that one?
Yeah, thanks, David. This is one that we covered on our Case of the Week, which is one of our segments on our Meet and Confer podcast. So I'm going to do just a short summary of it here, but for folks who are really interested in it, you'll want to check out that episode because it goes into more detail. This is a situation where the court sanctioned the defendant, who was Natera, and its lawyers for more than $3 million after they had already lost a $292 million verdict for failing to supervise the self-collection of emails by their expert witness and then doubling down on a series of misrepresentations to the court. The short version is really this. Natera's expert, Dr. Hochster, was deeply involved in a clinical trial that was run by the plaintiff. And that trial failed due to false positives on Guardant's cancer detection test. That failure may have helped Natera's defense. It's hard to know from the facts of the case whether the exclusion of that evidence really would have made a big difference for them. But instead of timely disclosing it, Dr. Hochster and Natera's lawyers, who were an AmLaw 100 law firm, said he did not have access to the trial results until they became public. And that turned out to be not true in the slightest. The expert actually had access to the results of the trial months early and had emailed those results directly to Natera's lawyers. Emails to the lawyers, which somehow didn't show up in discovery because, wait for it, Dr. Hochster searched his own inbox instead of having any lawyer supervision. And the court only learned the truth because Guardant subpoenaed Rutgers, where Dr. Hochster worked, and got dozens of emails that contradicted everything that Natera and their counsel had told the court. Even then, Natera still didn't come clean to the court and argued that they were shocked by the new information, even though some of those emails had been logged by their lawyers on a privilege log.
Whoops.
Yeah, big time whoops. The court didn't really mince words and found that the lawyers had knowingly and deliberately misled the court, and it issued evidentiary sanctions excluding the entire study which would have showed that Guardant's product was really inferior to Natera's product, likely, and issued $3 million in monetary sanctions just for the costs that Guardant had to incur as a result of the misconduct by the expert and Natera's counsel. Last week, the court appointed a special master to decide whether that $3 million should be attributed to the individual lawyers from Natera's law firm, and also determine whether there should be further punitive sanctions, as well as whether or not they should be reported to their individual state bars. So, huge cluster, enormous discovery implications, and it really highlights to me how complicated not only the discovery process is with the volumes of information that we have, but also how complicated it is to manage all of the aspects of litigation today, because these are clearly a huge miscommunication among the lawyers at the law firm as to who put these on the privilege log and how they were being handled.
Thanks, Kelly. Let's take a couple of topics from this one. There are some good ones. We've got the issue of self-collection. And for those of you in the audience who have never done electronic discovery, there used to be a hard and fast rule. You don't do self-collection. That is letting the client collect their own data and bring it to you. But many would argue that that's an impossibility. As we like to do on this program, let's take it around the world. We've got lawyers qualified in the United Kingdom, Ireland, and of course, South Africa here. Any of those perspectives, do you think it's physically possible to have pure collection where there's never any self-collection? Does modern technology help? Jonathan Armstrong, you want to dive in on this one?
I think from my point of view, I think you've always got to consider the issues around spoliation. And that might apply, whatever you're collecting data from. If you're collecting it for a subject access request, if you're collecting it for an investigation, if you're collecting it for litigation. My experience is that even though the tools have become more prevalent, particularly if you've got an enterprise 365 license, for example, that it's still a specialist task to collect data in a defensible way. So even if I had the client self-collecting, I'd probably want a grown-up in the room to check that they were doing it properly.
Anybody else want to jump in on this one?
I'd like to jump in on that, please. In the UK, under Practice Direction 57 AD, which governs disclosure, there is an obligation on parties and practitioners to ensure that they owe a duty to the court, that everything is done with integrity, and that includes collection and initial data governance. So if you are self-collecting, I think it does need to be done safely, but there's no prohibition on doing it. It also depends on the matter. If something is unduly complex, I think it is worth engaging a vendor to collect. But if it is straightforward, or for a DSAR or some very simple litigation, I wouldn't see an issue with self-collection.
Just to add my 2 pence, a lot of our work is under the UK jurisdiction, but I have the same views as Fiona. I think what I would add in is when people are thinking about self-collection from a reasonable and proportionate perspective and avoiding the cost of digital forensic fees, unfortunately, you end up having emails sent to lawyers by clients with legal advice saying, here's the attached really key evidence, or just here's a zip file of thousands of documents, and it really increases the cost not to collect at source, because you have a lot of work in trying to pull out what information actually falls within disclosure. And I'm sure Fiona will agree with me, particularly under the CPR, we're very busy dealing with what format the document should go in, and all sorts of questions come up. So even from outside of is self-collection the right way to go from an integrity perspective, it certainly is for me in terms of decomplicating the process.
I agree.
Yeah, I'll just add on to what everyone's saying, which I totally agree with. And I think there's a right? It's unsupervised collection that's really the problem, right? We call it self-collection, meaning that you're having but if the client is doing it all by themselves and you're not giving them guidance or ensuring that what they're doing is proper, that's where the problem is. And that supervision is going to vary depending on what the client is, what the source of ESI is. Generally, I try to be on a Zoom call with someone and go through their email and say, let's start with these search terms. Okay, I'm seeing some data that suggests there are more search terms. The whole search terms issue is another problem that I think layers on to self-collection. So it's a huge problem. We have a similar requirement to the one you were talking about in the UK, Fiona, and that is Rule 26G. That if lawyers certify responses, that means that they've done a reasonable inquiry. And there's a pretty well-regarded decision here, the M1 5100 decision from Judge Matthewman, who I think a lot of you guys have met because he's been at RelFest on the judicial panel multiple times, and wrote kind of the seminal case on self-collection in the United States.
Ah, jumbo supermarkets. Who could forget that tale of woe? That may have been the worst age discrimination case I have ever seen. Hey, there's a second issue here, and that is expert witnesses. It was an expert witness's involvement in this case that got us into trouble initially, of course. So, expert witnesses, how is that handled around the world? Jonathan Armstrong, is it an issue in the UK?
I'll let Fiona go first from a litigation perspective. I think we've had quite a lot of cases recently on expert witnesses not being expert. I don't know whether you followed them, Fiona.
What I was going to say is that there is an obligation under the CPO rules wherein expert witnesses owe a duty to the court. So if they do not act independently, the whole purpose is that there's an independence factor. They could be in contempt of court. So I think it's less likely in the UK from a professional point of view, from an integrity point of view, and also because of court sanctions, that experts will go rogue or have vested interests.
Experts going rogue. That sounds like a new TV show on your local network. Kelly has given us a nice segue in quoting M1 5100 from Judge Matthewman. And by the way, a big congratulations to Judge Matthewman, who has just ascended to the Chief U.S. Magistrate Judge of the U.S. Federal District Court for the District of South Florida. And the reason it's a nice segue is because we've got more U.S. case law news, and that brings up the issue that is all over the world, and that's generative artificial intelligence. There were two recent decisions. One of them is from Judge Matthewman, and they both involve sanctions for hallucinations in cases. And this is where you really get down to, in an article I've written recently, I call it the Lamborghini doctrine. And the Lamborghini doctrine is that a Lamborghini is a finely tuned Italian motor car. It can do many things. But would you use a Lamborghini, the $200,000 or more automobile, without an owner's manual and without a seatbelt? And the rules and guidance provide those seatbelts, but you've really got to take a moment to learn what's going on. And the sanctions were far more severe in one case. That was Bioplanet, and that involves a super disinfecting machine. There's litigation in Canada and the United States. But what got this lawyer into a lot of trouble was the serial use of hallucinated cases. And it was quite clear that the lawyer should have known, put on notice that there were hallucinations, yet used them in 8, not 1, not 2, not 3, not 4, not 5, not 6, not 7, but 8 different matters. The sanctions were severe. In Judge Matthewman's case, they fessed up pretty quickly. There was a little bit of a 2-week delay, but immediately apologized, tried to make things right, and Judge Matthewman noted that the sanctions would have been far worse had they not been honest about this. We've seen various levels of sanctions. There's been one lawyer disbarred. There have been others who face anything from fines. Sometimes the sanctions beyond the fines are even worse. Mata, that got us started in all this, that would be Mata v. Avianca. We've talked about that last time. It's been talked about a lot, but it wasn't so much the $5,000 fine, but it was the fact that they had to add a copy of the sanctions order to all the cases where the fake cases originated. What's different in our most recent case, Bioplanet, is that the lawyer was ordered for the next 2 years to attach a copy of the order to every single case he filed in that court. If it were me, I might just not practice in that court for a couple of years. But sanctions vary, and it really depends on the culpability. And being honest, as Judge Matthewman said, they were pretty honest and upfront as soon as it happened, and or otherwise the sanctions would have been a lot worse. We've got $5,000 fines. We've got attaching judgments. Let's take this over to merry old England. Fiona and Jonathan can jump in on this one because there could possibly be criminal sanctions. You think? Is it going to happen or what?
I think that's likely, and I think there are two camps, aren't there, with hallucinations? And I know we talked about this at the Ayinde case last time round, but I think there's one camp where the lawyer doubles down and pretends it isn't happening, and there's a second camp where the lawyer probably genuinely doesn't know that they were using AI. And I think that second camp, we're going to see more of these type of cases because a lot of search engines are embedding AI. And whilst ever firms don't educate their lawyers correctly to question the search results of common search engines, as well as opening up GenAI, then we're going to see more in camp two, if you like, the accidental use of hallucinations. But I think cases like Ayinde are in camp one, aren't they, of a lawyer who seemingly has repeatedly used AI. There seems to be evidence that she also used it in another case, and then doubles down and isn't transparent with the judge. And it's one of the oldest rules in the book, isn't it? That if you make a mistake in front of a judge, you fess up quickly, you apologize, and you try and stop the bleeding, if you like. And I think lawyers who double down and say things like, it's not up to me to do your legal research, are going to potentially end up in jail. And I know we covered it last time, but one of the really instructive things I think that Dame Victoria Sharp said is that sometimes the court's powers will not be enough. And as a reminder, the court's powers are, I think, 2 years for contempt. And she said in some cases, 2 years won't be enough. And the judges will be expected to call the police to ask them to investigate the possible offence of perverting the course of justice, which then has a maximum of life imprisonment. So I don't think we're going to see many life imprisonment cases. I know we've seen a jail term of 12 months under that context, not an AI case. But jail is a possibility, I think, for lawyers in extreme cases, particularly those in camp one that try and don't do what they can to stop the bleeding early.
All right, we've got the Jonathan Armstrong tourniquet doctrine. Stop the bleeding, fess up immediately, and try to mitigate the damages. Fiona Campbell, I assume we all agree on the Armstrong tourniquet doctrine. What further takes do you have on these two cases?
I do agree with that, but I think what the Ayinde judgment does is it reaffirms professional duties, and that's imposed not just by the Bar Standards Board, but also the Solicitors Regulation Authority. And both of these professional duties apply equally to AI-generated content. So across both branches of the professions, lawyers have to not mislead the court, ensure accuracy, assist the court, act with honesty, integrity, and competence. These are all very basic things, but they were lacking in the Hammett hearings of Ayinde, which was held in tandem with Al Haroon.
Excellent. Let's go further on the globe and go down to South Africa with Linda Sheehan. We've got potential criminal sanctions, perhaps ending up in the Tower of London. In the US, we've got everything from monetary sanctions to shaming you with orders that you've got to give and copy onto your pleadings. How severe are the sanctions going to be in South Africa?
So I think I say this often that we heavily look to the UK. So we've got our own places in South Africa where it might happen, but our laws are very similar. I'm not legally qualified in South Africa, so I'll come back to you on whether we go beyond the 10 years, but I imagine we're very similar. I'd also, we've had another AI hallucination case come out in South Africa since our last episode. And it very much endorses Ayinde. So we've got exactly the same authorities on this side, and we're very much taking the same stance as Ayinde. It's now in South African case law. The fact pattern is a little bit interesting on this one, because it is not a ChatGPT or maybe a subscription, online subscription that other people are aware of, because it's a very specific South African legal database that was used. So quite interestingly, even just where we've got, promoted databases that it's exclusively trained on South Africa legal precedent, what I think people are misunderstanding, that does not mean that it's unable to hallucinate. I mean, it was very similar fact patterns, but I think what's interesting is that we're really seeing it on lots of different tools and technologies. And one of the nice differentiators that came out of this one is that the same, there was apologies, there was showing no deliberate attempt to mislead the court, and there was also an argument around that it was within the written arguments, not the oral arguments. But the court very much found that it doesn't matter whether it was intended or not. The same principles that you're seeing in Ayinde, the same principles you're seeing in a case from earlier this year. These lawyers are all being reported to our Legal Practice Council.
Thanks, Linda. And of course, with South Africa being not dependent, why don't we say borrowing from the laws of England and Wales? You're certainly not the only ones in the United States. We anarchist colonists take a lot of our law from England and Wales. And here is today's episode's fun fact. I'm actually licensed in Washington, D.C., and in the District of Columbia, there are laws on the books, but the law in many ways is based on Maryland. If D.C. law is ever silent, it goes to Maryland law, because the capital of the United States used to be part in Virginia, part in Maryland, and relying on Maryland law. Your fun fact for today.
Can I?
Please jump in, Linda.
Sorry, may I add a fun fact that excited me in another AI hallucination case, is that the Caribbean is referring to South African law, which, it's great to see that we're being referenced and relied upon. Unfortunately, I don't think that we're going to be very happy that they're using the AI hallucination case as a reason to reference South African law, but...
Might be a good reason to visit, though.
Yes.
Exactly.
As an expert.
Yeah.
On that, it was actually about an ex-employee who had gone to St. Kitts on the company's pockets to go and do some studying. So it was quite an interesting case where it's a completely separate, but they claimed constructive dismissal as a counterclaim, but the claim against them was just because they left a few weeks after a very nice, expensive 2-month holiday or study program in St. Kitts, which sounded wonderful.
Nice. And the database that you referenced, David, highlights the fact that there have been cases in Trinidad and Tobago. So I suppose if the Trinidad and Tobago bar want to hire the I-team in the midst of our winter to go and do some AI education there, I suppose we should take one for the team and volunteer.
Yet another brilliant suggestion.
I'm going to add myself as an honorary member of that in advance of that trip, please. Yeah.
Can we positively touch on the difference as well between OpenAI and licensed AI? Because if we look at most of these, I would say all of these, because to confess, I haven't looked at all of them, but most of them, and most of the ones I've looked at, concern OpenAI hallucinations.
By open, you mean GenAI
Right.
rather than ChatGPT?
I mean GenAI versus licensed AI.
Right, she means little o, not a
Yeah.
capital letter O,
Yeah.
but a little o on that.
Yeah, rather than the licensed AI. And I think it is crucial to distinguish between open source and licensed Gen AI models, because open source tools, such as, let's not name them individually, but we all know who they are, they're freely accessible, but they're not designed for legal use. And they are designed to favour producing a response over remaining silence, even where there's no reliable content in existence. So this is where the hallucinations are coming from. You get plausible but false information generated, and that's the risks we are seeing. Now, with something that is licensed, those are less likely. However, from the courts, from guidance, from anything that we've seen, including the Ayinde judgment, what the courts have said is, irrespective of any AI output, it still needs to be independently verified. And I know we have talked about criminal sanctions, but those aren't the only sanctions within the court's arsenal. They can refer you to the regulator. If you're a solicitor or a barrister in the UK, you risk losing your practicing cert. Things like wasted cost orders, which, you know, not massive in the general scheme of things, but still look bad professionally. Contempt proceedings as well, and then you have public criticism and the shame associated with any kind of AI misuse.
Can I jump in here too, David? That
Sure.
hallucinations are one piece of the problem
Yeah.
in using generative AI for legal. But the other piece is, even if you give it the good information or you ask it an outright question, because I've used it a lot and I've seen that its reasoning capabilities are very limited. And so I've seen it tell me that a case says X, and I go, well, I don't think that's what that case says. And then I go back and read the case, and in fact, the case says the exact opposite.
Yeah.
So you can use it as a starting point to identify decisions on the topics, but I would be very cautious in relying on the reasoning of any AI model right now. That may improve.
Yeah, I was on the New York State Bar Association task force, and I think the conclusion we came to is you should treat the product at best as a first year graduate in your law firm, and we and the task force is now reconvened, and we're looking at some new updated guidance. And one of the things we're thinking of, spoiler alert, Fiona, is exactly as you described. So a list of good AI and a list of bad AI, and that won't take away the duty of the lawyer to supervise good and bad AI, but it will give warning bells. So there'll be a presumption that if you supervise properly and you've used it off the good list, you've met your professional responsibilities, and you will need to persuade a court, a regulator, whatever, if you've used anything off the bad list. So there's an attempt to try and help lawyers by steering them away, because we know from the work we did as a task force that the error rate is 75% of some Gen AI applications when you ask it legal questions.
But it can still pass the New York State Bar.
Right.
Well, can it? That's another podcast.
Yeah.
That'll be a good one.
But, you know, in saying that, I know we have these good lists and the bad lists. However, I think the overarching sentiment from guidance and the courts is that Gen AI is no substitute for legal judgment. Irrespective of what Gen AI is used, all outputs must be independently verified, and responsibility cannot be outsourced to AI. So where lawyers do fall short, serious regulatory and judicial consequences will follow, and we have covered those.
Absolutely, and that's a great point. In the article that I wrote this week, I covered 4 different cases, and in each of the 4 cases, some of the judges we know well, U.S. District Judge Xavier Rodriguez, we've talked about Chief Magistrate Judge Matthewman, and they all have come out and said there's nothing wrong with using AI. Judge Castle, who got us all started in MATA, I'll give you a quote on this one. Technological advances are commonplace, and there is nothing inherently improper about using a reliable artificial intelligence tool for assistance. And here's to Fiona's point, but existing rules impose a gatekeeping role on attorneys to ensure the accuracy of their filings. I think it's kind of like a great compass. Generative AI is wonderful for pointing you in the right direction, but all right, it's pointed you in the right direction. There are still lions and tigers and bears out there, and you're certainly not going to rely solely on the compass.
Yeah.
It is a tool, not something that's going to do your job for you.
Yeah.
Correct.
All right, we talked about education. There's also a theme here on the ability to learn this stuff. We do a lot of continuing legal education classes. All 5 of us here have had the pleasure of doing them together. But Linda, I think we have some news in South Africa of what maybe university in Cape Town may be doing.
Yes, that's right. So we've recently just in the news had headlines such as University of Cape Town scraps flawed AI detectors. I think there may be a little bit of hype in the suggested title. I don't think that the AI detectors are necessarily flawed. I think it's the way that the results are being used. So paraphrasing quite badly here to keep the time down, but as we all know, there's been a lot of detectors on did someone write this or did AI write this? And that's been used, as you know, in education around the globe. University of Cape Town shouldn't be called out on this, but they are looking at did this person write their own thesis? And they're getting scored by AI on whether some of the paragraphs, the whole of the essay is actually written by AI. Now, the way that they're working with the percentages and statistics from the AI output is basically saying if it says 30%, they think 30% of the essay was written by AI, and the students are actually getting interrogated by their educators. And when you look into the detail, it doesn't actually show that the information was written by AI. And I think why it's really interesting to me, other than, what must be a very difficult time for a student to feel that the whole time they're getting questioned, is also just looking at when we go to, court and someone says this was written by AI. How are you going to determine that? I mean, we're looking at, are we giving fake citations? The next thing is what is actually real documents and what is created by AI, and how are we actually going to handle that during our litigation processes or investigation and so on?
I think we should turn this episode into the defense of the M-dash. And that is, you've probably seen that one of the way these detectors Linda refers to allegedly detect AI writing is the use of the M-dash. And for those of you who use different terms for it, it's the long dash, a glorified hyphen that you use. And it's a wonderful tool to separate a sentence up or to separate a whole paragraph up. Now, and Stephanie Wilkins, the director of content at Legal Tech Hub, and I are going to make this our crusade to defend the M-dash because it's a great tool. And my point here is that the detectors are not always accurate.
But what's wrong with the semicolon?
And Kelly, you had something to add to this.
That, there's code that gets put in AI generated text that, if you're going to copy and paste AI generated text, you need to remove that code because otherwise it's very easily detectable.
But interestingly, the UK Jurisdictional Task Force is currently working on a statement about AI liability or liability for content created by AI. And what they're looking at is whether this liability for harm caused by AI, by third parties, fits into the existing law of torts, or whether new legislation or statutory intervention is needed in the UK, which I think is incredibly interesting.
I was going to say, just coming back to, I guess, going back to the AI detectors as well, I think what's interesting, and maybe goes to Fiona's point, is around how they're scrapping the AI detectors, but what they're actually trying to achieve is to incorporate AI into the way that they mark and assess people, because actually this is the new way of doing things. So it's not necessarily about, did I use AI and now I'm fraudulent or I'm, plagiarizing? Shouldn't it be, did I use AI correctly to the point that it made me more efficient.
But does that not take away individual flair of writing?
Exactly.
I'm not sure if that's a good or bad thing if you're being marked by AI. And as well, it's quite subjective.
I do another podcast with Professor Eric Sinbod, who's a law professor in California, and he sets an assignment for his students every year, which says, answer the following question with AI, and then tell me why it's wrong.
Yeah.
That's a great exercise.
Yeah, I think so.
I might do that with my law school class. That's a fantastic exercise because
I'm going to do that too.
the very first thing that happened last year or 2 years ago, this is 2 years right after ChatGPT came out, I taught in the fall. So it came out in March 2023, I taught in the fall. And one guy in my class stood up and said, why can't I use ChatGPT for legal research?
Yeah.
Flat out.
Nothing stopping you, just verify.
I teach at Fordham, and I've had a student submit her end of term coursework, which almost certainly was AI generated, off topic, wrong, badly written, and she defended it to the hilt as if it was her own work.
Unreal.
I suspect that's happening to teachers the world over now.
Well, I'll tell you this too. If you ask a ChatGPT what are the most recent cases on a particular issue, it will give you cases from at minimum 3 to 4 years ago. In our space, in discovery in the United States, that is outdated case law.
Yeah.
Like that's why what we do at Minerva is make the most recent case law available on discovery issues, because you have to be up to speed with what the courts are saying now based on what technology was. So there are a lot of limitations to GenAI in our space.
Yeah.
Can I loop back to the plagiarizing
Please.
discussion? So, I mean, I don't think it's plagiarizing when you need to refer to source content. And I'm going to say everybody on this call would have referenced a book or taken excerpts from a book and reworded it in your own style when you had law school or university papers to submit. So relying on AI is almost like the next evolutionary step in how things are drafted, but you're still referencing something, not plucking it out of the air.
Exactly. It's the use of AI that needs to be considered in the way that they're being educated, because when you go into the real world, you will be using this stuff.
Yeah.
So if you're using traditional methods, then you're not setting people up the right way. So I think the switch, particularly with this recent news, is rather than check work with AI, change the way that we educate, which is not a new concept, but change the way that we're educating so that it's fully embedded in the real world and how we're embracing this technology.
It's interesting, at Duquesne's Klein School of Law, where I teach, you've got 3 policy options you can give to the students. You can give them the open statement, the moderate statement, and the restrictive statement. We're going to have them using AI tools, and so we're obviously using the open one in this class, but listen to the restrictive statement. All work submitted by students in this course must be original and generated by the students themselves. Assignments must be completed without substantive assistance from others, including automated tools. Using generative artificial intelligence tools in classwork is prohibited and will be treated as a violation of academic integrity.
Wow.
I'm not sure how that works in any tech class, but it'll be interesting to get the data on that one.
I'm not sure how that works in life anymore.
Well, that's a good point.
How does it work in law when it's all based on precedent?
Stare decisis, counselor. Well put.
Yeah, and I think there's a generational thing, isn't there? I mean, speaking as a Gen Z myself, people will evade rules like that, won't they? If they're set and they're given as stark and as binary a way as you suggested.
I wasn't aware that we had expanded Gen Z to encompass the entire Gen A.
Well, yeah, I'm Gen A. I'm useful here.
That's news to me, but it makes me feel 30 years younger, Jonathan. Thank you.
If it wasn't for you pesky kids, I would have got away with that.
Then you can be Gen AI, Jonathan.
If I'd asked my kids, sure. Yes, you're right.
All right, we have done everything from expert witnesses to the M-dash to the youthful Jonathan Armstrong. But Kelly Twigger, our special guest this episode, thank you so much for joining us.
Thanks so much for having me, David. This was a blast. You guys are the best. I look forward to seeing you at Fest in the fall.
Absolutely. For Jonathan Armstrong, Linda Sheehan, and Fiona Campbell, I'm David Horrigan. Thank you for joining us, and we'll see you next time on the I-Team.